Ladies and gentlemen, we have a quorum. Please take your seats. The town clerk has informed me that we have a quorum, and I call to order the third and last session of the annual town meeting. I have no announcements, so we'll start right in with Article 12 and move on immediately to Article 13 since no motion is being offered under Article 12. Article 13, the motion requiring a two-thirds vote is on page 13-5 over to page 13-6, moved by Ms. Hyatt, seconded by Mr. Fry, that the town amend the Brookline zoning law as indicated in the bold-faced print on the top of page 13-6. Mr. Fry.
Thank you, Mr. Moderator. Ernie Fry, Precinct 7. This small change to our zoning bylaw with this warrant article is intended to greatly expand transparency and communications to residents when improvements are contemplated to properties in their neighborhoods. The zoning bylaw lays out two preliminary steps for a property owner or applicant in the language of the zoning bylaw before a formal submission of their plans to the building department. They are encouraged to, 1, consult with the building and planning departments, and 2, hold a neighborhood meeting for all abutters, town meeting members, neighborhood associations, and other interested groups. For a major impact project, both steps are required. A major impact project is one which meets any of the following criteria: a residential development of 16 units or more, a non-residential development of 25,000 square feet, or any other project with substantial environmental impact on the community as determined by the planning or building departments. Certainly, the planning and building departments can plan their availability to meet with the applicant according to their respective schedules. However, the neighborhood meeting cannot be similarly scheduled, and advance notice must be provided to all potential attendees. There is nothing in the current bylaw that specifies the lead time the applicant must provide for that neighborhood meeting. The primary objective of this warrant article is to remedy that inadvertent omission, requiring mailing or delivering of the notice at least 7 days prior to the meeting. It also requires rescheduling the meeting if the specified lead time is not provided. According to the current bylaw, town meeting members are to be notified of the neighborhood meeting, but there is no clear statement as to which town meeting members are to be so notified. I believe applicants would rely on the Abutters app on the town website to determine which properties are within a 300-foot circle of the property proposed for improvement, the owners of which are defined as abutters. This app can produce mailing labels and a spreadsheet of mailing addresses of abutters to facilitate the notifications. But the only town meeting members who are listed in this app are those who happen also to be abutters. The warrant article expands the notification responsibility of applicants to include town meeting members who represent property owners of the abutters identified by the Abutters app. This utility was recently updated to show precinct boundaries so that an applicant can clearly understand which town meeting members must be alerted for the neighborhood meeting. The current bylaw also states that neighborhood associations and other interested groups should be notified of any proposed improvement. The building department has a list of neighborhood associations that may be used for this purpose, and I've been seeking assistance from the Brookline Neighborhood Alliance to see how that list may be used more effectively for the applicant's notification responsibilities. The Abutters app also lists neighborhood conservation districts, which the contact information should also be distributed to an applicant. This warrant article is about timely circulation of information about property improvements to neighbors and Brookline residents who might be affected by a proposed property improvement. Provides an opportunity for an applicant and the neighbors to freely discuss the proposal so that each may contribute to the agreement for improvements which shall be beneficial to the Brookline community. I thank the Planning Department for their providing clarifying wording that would be acceptable to applicants and to the boards and committees reviewing this article, and the support of Selectmen, the Advisory Committee, the Planning Board, Zoning Bylaw Committee, and PACS is very much appreciated. I appeal to this town meeting to also provide support to this warrant article and to this modification to the zoning bylaw. Thank you very much.
Thank you, Ms. Hyatt.
Angela Hyatt speaking for the Advisory Committee. Mr. Fry gave a good background of his warrant article, so I'll just add that the Advisory Committee sees Article 13 not as anti-development, but rather a way to keep Brookline citizens better informed about potential projects so that ultimately these projects can benefit from neighborhood feedback early in the design process. The amendments proposed in Article 13 are an important step forward, but the Advisory Committee suggests that a future town meeting might consider these notification procedures more broadly across the zoning bylaw so that the various boards and commissions could have more of a universal system for notification. But for now, the Advisory Committee is in full support of the clarifications proposed in this amendment, and therefore, by a vote of 1903, recommends favorable action on Article 13 as submitted.
Thank you, Mr. Green.
The improved notice requirements of Warrant Article 13.
Let's announce who we are, sir.
Sorry. Bernard Green for the Board of Selectmen. The improved notice requirements of Warrant Article 13 are fairly straightforward and non-controversial. The Board of Selectmen agrees with the petitioner's justification for this warrant article and the comments of the Advisory Committee. And by a vote of 5-0 on April 19, we recommended favorable action. Thank you.
On the motion on page,
Quick
Mr.
comment,
Rosenthal.
please. Yeah, Marty Rosenthal, Precinct 9, and co-chair of PACS. I was quiet the second night. I just want to reiterate, this is one of the most important areas where it does no good for people to be notified about meetings if they can't get easy access to what's going to be discussed. So I'm just reiterating my nudge about getting plans posted online with a meeting notice telling how to get them. Thank you very much.
Thank you. On the motion on page 13-5, those in favor, please raise your hands. Those opposed? Those abstaining? Motion carries unanimously. Article 14. The motion offered under Article 14 by the petitioner is on the salmon-colored supplement number 1, that the town accept the provisions of Section 148C of Chapter 149 relating to earned sick time. It's moved by Ms. Connors, seconded by Ms. Van Der Zee. Ms. Connors.
Thank you, Mr. Moderator. Patricia Connors, Town Meeting Member, Precinct 3. Imagine, if you will, you're a part-time employee who's worked for the town for a number of years. You know that the town has hired part-time employees historically, in large part, so it need not pay them benefits. You hear about a state law passing in 2014 that requires employers to provide sick time benefits to its part-time employees in the amount of 1 hour of sick time for every 30 hours worked up to 40 hours per year. Only thing is, the law exempts municipal employers unless the municipal legislative body adopts the law. In Brookline, that legislative body is town meeting. Now, last summer you hear that a warrant article is being brought asking town meeting to adopt the state-earned sick time law. You begin to follow the proceedings of the warrant article. And then you hear that the town has amended its sick leave policy for part-time employees effective October 1st, 2015. And then you wait October, November, December, January, February go by. Your paychecks and those of your part-time colleagues reflect no accrual of sick time, nor have you and your colleagues been paid for valid sick time that you've requested. You receive no direct notice of the actual sick time policy. You write a letter to the petitioners of the 2015 sick time warrant article that you're disappointed that that warrant article failed, and explain how there's been absolutely no communication from the town to you and your colleagues about this matter. You write the letter anonymously out of concern for a backlash, saying that some outside pressure needs to be applied. In March 2016, you hear that the petitioners have filed another warrant article, again asking town meeting to adopt the state-earned sick time law. You follow the proceedings, all the while still not getting any communication from the town about its new sick time policy. On April 19th, 2016, you watch the selectmen review this warrant article and hear a report of how a payroll systems glitch is responsible for the employees not having gotten notice of the accrual of their sick time benefits since October 1st, 2015. You might expect an apology, a promise to do better, but you don't get an apology or a promise to do better. You get excuses and more excuses. I say we owe more to our town employees than excuses. We owe them the assurance that adopting the state-earned sick time law will give them, because then they will get, one, better substantive benefits, for example, the ability to use up to 40 hours of their accrued sick time per year for preventative medical care for both themselves and immediate family members. And two, better procedural benefits. For example, the state authority to enforce the town's compliance with this law so that employees need not resort to sending anonymous letters to town meeting members regarding the town's lack of implementation of its sick time policy.
You have 1 minute.
For fear of a backlash. I urge you to vote yes on warrant Article 14 to adopt the state-earned sick time law. Thank you.
Thank you, Mr. Green. And Ms. Van Der Zee, will you please come forward?
Well, I must say it's difficult to follow that. Bernard Green for the Board of Selectmen. It's difficult to follow that. The Board of Selectmen asked the Human Resources Director and our town administrator to address those issues and address the issue of whether back in November and then again this year, whether the current policies, benefit policies for the town were so deficient that we needed to adopt the state law. And we were told by the Human Resources Director and the town administrator that for very specific reasons, our policies, which are addressed to the specific and unique conditions of town employment, were the preferred approach to take. We base our decisions on that. We can't really respond to anonymous letters that assert other things. So I'm not suggesting that that's not the case. I'm just suggesting that it's not something that we can act on. Warrant Article 14, which is basically the same warrant article as was introduced in November of 2015 as Warrant Article 7, would have the town adopt the state's paid sick leave law in lieu of the paid sick leave provisions that are in the town's union contracts and the classification and pay plan of the town. In November, the advisory committee and the board of selectmen recommended to town meeting that the state law not be adopted, rather that the current new amended classification and pay plan provisions be continued because they address the specific issues facing the town of Brookline and its negotiated union contracts that have been negotiated over many years, and it was a better course of action. Town meeting agreed in November, and of course we're back recommending that no action be taken on this article, Warrant Article 14. And I guess let me remind the town meeting of the issues that were discussed and debated at the November town meeting with respect to what was then Warrant Article 7. The petitioners argued that under the state law, employees may use up to 40 hours of accrued sick time per year for preventative medical care or other purposes for themselves or immediate family members, which was not available under the town provisions, which is true, but what we provide are 8 hours of personal time which can be used for preventative medical care or any other purpose. With the September amendment, town employees get that more flexible benefit, which in our view is the preferred approach to dealing with this problem. In addition, all town employees have the ability to ask their departments to change their schedules, and they're given extensive latitude, or town departments are given extensive latitude to accommodate those requests. Second, the petitioners argued that the state law permits employees, with some exceptions, to use sick time in hourly increments, while under the town policy, they may only be used in half-day increments, unless otherwise allowed by individual departments. And that exception, the unless otherwise allowed by individual departments, is available to any employee and is really the key protection for employees who need to take shorter periods of time than a half day, except in situations where that's just not feasible. Police and fire are ones that come to mind. One strict rule does not work for the broad variety of work environments that we have throughout the town. So we put in place that half-day minimum to address the types of situations that we face, while giving town departments opportunities to accommodate any worker who needs a lesser amount. Third, the petitioners argue that by adopting the state law, school employees would be covered by paid sick leave provisions. It's my understanding that the school committee has adopted substantially the same provisions that the Board of Selectmen adopted. Finally, the petitioners also argue that the state law has record-keeping requirements, notice requirements, and prohibitions on retaliation. They also note that the Attorney General can enforce the town law. We have addressed those issues in the town, and I guess what I want to sort of end with is that we have a system that is designed to provide benefits to employees that are consistent with our long negotiated union contracts. I don't think anyone should suggest that the town of Brookline is out to get their employees and is out to deny their employees benefits that are provided either in the union contract or under our classification and pay plan. The town of Brookline takes the new state law mandate very seriously. We're not trying to cheat our employees or undermine their rights. We do have an obligation, however, to consider the impact of adopting the state law on our ability to provide services to our employees and avoid challenges and potential litigation over the interpretation of contract and statutory provisions that may overlap and be inconsistent. Therefore, by a vote of 5-0 at the April 26, 2016 meeting, the Board of Selectmen recommended no action on Warrant Article 14, which is what we recommend tonight. Thank you.
Thank you, Ms. Van Der Zee.
Cornelia Van Der Zee, Precinct 15, and co-petitioner for this warrant article. I just want to correct one thing that I hope people don't misunderstand about this, the state law. The state law does says, and I'm talking about the increments in which people can use their sick leave. If an employee works in a unit where someone has to cover the whole shift, you can't just take an hour here or there, that's the way their contract is, then the employee has to take the whole shift. They can't take it on an hourly basis. I hope I made that clear. So, as Tricia said, when we got the letter, we thought we would look into this a little more, and at that point we saw that the schools had not promulgated any earned sick leave policy. And I'm here mainly to talk about the school side of it. So on on April 28th of this year, the school committee did adopt its own sick leave policy, which was almost word for word the same as the town policy. The school's exemptions, however, are important. In addition to student interns, co-op students, and those receiving stipends, the schools specifically exempt short-term substitute teachers from their policy. We attended a meeting and I asked the question, what constitutes long-term versus short-term, and the members of the school department weren't really sure about this, but it looks like it might be 90 school days, which is half of the school year, to make someone a long-term sub. I think the school year is 180 school days. For most of the short-term subs, the exclusion may not make any difference, but for some who are called upon over and over during the school year, it may, for different jobs throughout the year, it may indeed make a difference. Some teachers know in advance when they have to be out, and they may ask for the same sub over and over again because that sub knows their students, etc. And we feel that so that the short-term subs should be able also to earn sick leave. The other sub positions include nurses, aides, and kitchen workers. There may be other part-time people who are sub positions that may be covered. I'm not sure about that. Remember that a school day, I believe, is considered something like 6 1/3 hours, maybe. So someone needs, regardless, someone needs to work 30 days to get a full day's sick time, 30 school days. We've also heard there are problematic issues in reconciling state law and the town school policy. So we called the Attorney General's office about that. Are those eligible on stipends? Eligible for sick pay? Probably not, or it seems not from what the Attorney General's office said. Have there been issues regarding union contracts? We've heard allusions to, but no definite problems associated with this coming from the town here. To the best of the knowledge of the person contacted in the Attorney General's office, there do not seem to have been any problems to date. Remember, the state does have unionized employees, as do private employers. Have any other municipalities signed on to this? They thought one had, but they couldn't give us the name. And the most important question, would the school committee be bound by a favorable vote of town meeting? The Attorney General's office would not weigh in on this. They said it depends on the town laws. The town council has come out last fall saying yes it would, now saying no it won't. I don't know what the law is on that. There seems to be no clear consensus. And also remember that the state law only sets the floor. Any benefits that are more generous than the state law would stand. It's only those that are less generous that would stand. So let's consider doing the right thing
You
here.
have 1 minute.
Town meeting has no problem in voting in support of resolutions that have non-binding effects on many issues, not to denigrate such resolutions or minimize their importance. Let's try to extend the same spirit to our poorly paid short-term subs, the teachers of whom earn $105 for a school day and no benefits, some of whom may work many hours and could accrue earned sick leave. Please vote favorable action on Article 14 as proposed by.
Thank you, Ms. Gilbert. And Mr. Jones, would you come forward and sit in the front row, please?
Janet Gelbart speaking for the Advisory Committee. The Advisory Committee, by a vote of 20 to 3 to nothing, voted no action on Warrant Article 14. Brookline's employees, their regular employees who work more than 18.75 hours a week, more than 26 weeks a year, have much more generous benefits than the state law would afford. The town did not need to do anything, but in the spirit of the state law, it passed a policy that covered those other very short-term, very part-time workers. We are talking about people who, for the most part, work less than 16 hours per week. Temporary and seasonal employees may work longer hours per week, but they don't work a full year. They don't work more than half a year. So we've met the spirit of the law. There are some nuances in the letter of the law. Number one, I think it's highly improbable that the Attorney General would come in and arbitrate every time an employee said, somebody owes me some sick leave. They will reserve their firepower for employers who, by and large, are not granting benefits to their staff. The requirement that people work, it's 1/2, not day, 1/2 of their normal day, which for most of these employees is a 4-hour day, so it would be a 2-hour increment of time, and their supervisor can let them use less time. It's really a matter of if the work of the department gets done. As for medical appointments, these employees, it is reasonable to believe that employees working such minimal hours could schedule their regular medical appointments not during their regular work hours. And in those instances where they need to, they have been granted personal time. And if they never get sick and they don't need to use any of these hours, they have 8 hours, can accrue up to 8 hours to use any way they choose. 1/3 of these employees, because I got the statistics and I counted them, 1/3 of these employees work less than 9 hours a week. That means they could accrue a week off if they never became sick. That's a huge benefit not afforded by the state law. The costs of adopting the state law are not known. There are potentials for litigation. There are potentials for conflict. Since the town's policy with regard to these employees mirrors their union contracts and our unions have not been negotiating for different benefits, we have to assume that this system works for the majority of the employees. Will it ever, any system ever cover 100% of every employee all of the time? Not possible. You could get the 15 days afforded to a regular employee and still need more sick time in a given year if something more bad were to happen to you. So in summary, Brookline has been a leader not in adopting the state law, but I looked at the websites of all of the usual peer towns. I didn't see anybody who's done anything for these very part-time employees with the exception of Concord, which will allow a less than half-time temporary or seasonal employee to use sick leave with the approval of the town administrator and the personnel board. That seems like a bigger hurdle than we've asked our employees to cross. The policy has only been in effect for 8 months. That's not enough time to see if all of the parts of it are working or not working or could work better. As long as it's town policy, the town can always tweak it and amend it. Can the town approve its communication? I'm not a part of the group to know what the communication has been. I know that the Attorney General would not respond to an anonymous complaint. They would say, who's calling, please?
You have 1 minute.
Okay. So it makes no sense for this small group of employees who have a benefit they never had before to override the years and years and years of contract negotiation. So I urge you to vote no on no action on Article 14. Thank you.
Yeah, you're being asked to vote no action by those against the article. Of course, the voting against the motion before you will constitute, in effect, a no action vote. Mr. Jones.
Thank you, Mr. Moderator. Gary Jones, Precinct 3, and also library trustee. And library trustee is where I've become very friendly with the library workers. And my experience with the part-time employees in the town of Brookline are with those people, and there are many of them in the library that work part-time. And I want to say one thing. I've sat here the last couple of nights last week, and I see that the Earth has members of town meetings speaking for the Earth. You know, they're speaking for the environment. And I see people speaking for the teachers. I see people speaking for highly paid town employees. But I see a lack of voices speaking for the lowest paid town employees, the part-time people. And I don't know if you ever go home and want to get a library book, you go to your computer and you put in and you go to the Minuteman Network or the Brookline Library, you know, website. Oh, I want to order that book. If it comes from Newton or Wellesley, someplace in the Minuteman Network, somebody has to go to that shelf in another town or this town, take it off, and put it in a box for you. All of these books that are flying around the Minuteman Network, and Brookline sends out more books than we get in. People, the part-time employees, are doing this, and it's very, very labor intensive. And I want to make a point that they are the lowest paid employees, and you know what? The town of Brookline saves a lot of money. For every 2 part-time employees, that's 1 less full-time employee they have to pay. It's 1 less full-time employee they have to pay full health benefits for. It's 1 less full-time employee they have to pay pension benefits for. Part-time employees save the town of Brookline an awful lot of money. And some of us think there may be too many part-time employees. Now, I spoke on this article last year, and I made mention of a man in the Brookline Public Library that had a part-time job in Brookline and a part-time job in the City of Boston Library. His part-time job in Brookline was for the Brookline Public Library. A wonderful, hard-working man, but he had to combine 2 part-time jobs to get basically a low salary, and he had no health benefits. And when we got last year, when the town of Brookline, and I'm grateful to the town of Brookline for what they did, because I think it was the right thing to do. And I'll tell you something, it was appreciated by people like him that were part-time employees. Now they had a benefit that they didn't have before. And I want to tell you why it's important that the town, in Article 14, adopt a state law. Have you ever tried to get a doctor's appointment when you want it? I mean, oftentimes the doctors, especially the specialists, they're only there a couple of days a week, and you have to do it well in advance. And on this article, if we vote for Article 14, and I certainly hope that we do, people that are part-time employees can rest assured they can make a doctor's appointment and not have to schedule it around some problem that the town, it seems to me the town has a problem with their computer system. But you know what? I'm thinking about it not from the point about town administrators and town bureaucrats, but what about the part-time employee? These three things.
Well,
Agreements.
you have 1 minute for those three things, Mr. Jones.
I'm finished?
No, you have 1 minute.
Well, as we know, allowing them to have accrued sick time. Accrued means that they earn the sick time. The town's not giving them the time off. They've earned it. And secondly, they may need to take it in hourly increments. And thirdly, I think a grievance procedure is always needed. Thank you. And I hope you vote for Article 14.
Thank you. Ms. Daly?
Yes, Nancy Daly from the Board of Selectmen. I wonder if we might have Ms. DeBoe clarify exactly what she thinks the effect on our carefully bargained contracts would be if we pass this. And the second point I'd like her to address
Ms. DeBoe, would you come forward, please?
Which of our part-time employees are covered now, and there was, the glitch in notification.
And Mr. Kleckner, would you prefer to field that? Okay. Just stretching. Or just coaching?
Good evening, Sandra DeBoe, Human Resources Director. So we value our part-time employees, we value our less than part-time employees, and that is primarily who this applies to, anybody who works less than 18.5 hours. The reason why there was a computer glitch, if you will, is we have an extremely difficult, we have an extremely complicated workforce. And one of the most difficult is not the library employees. The library employees are great. They have fairly regular schedules. We know when they're going to work. It's the recreation employees, which are the vast majority of the employees, who hold different positions at different pay rates and work varying hours in all of them. And so to capture that in our payroll system has not been easy. However, we have done a very good job at doing it with paper and pencil. And although most people can see their accruals because they're printed automatically, because it is a manual system in many regards, with regard particularly to the recreation employees, it continues to be not appearing on their paycheck. But that does not mean they don't have accrued time, and they can use it, and they have been. I believe there was an issue regarding notice, too, that we've done training on this policy. We did training on November 9th and November 16th, specifically to employees who were in this class and pay plan. Not only was the information presented, but it was released. It's on the intranet. All the department heads, because it's complicated with the way we administer it through the payroll system, we've been working very closely with all the departments, and they assure me that their employees are not only aware of, but are using this new benefit. Okay, so contracts. So our contracts have been bargained over many decades. The vast majority of our employees fall under these contracts. We have very specific work rules that have been fine-tuned by both sides. So all of our policies, all of our contracts, for the most part, for example, say you use sick time when you're sick, and you use personal time if you're not sick. And when that happens and how that plays out under each of our different contracts is slightly different due to the interests of the town and that workforce, and due to the interests of the union that they have. So we have worked very hard over, again, decades, for example, to talk about who is a family member when it comes to bereavement leave. Or if somebody has to be called back to fill in for overtime, do they get to be paid the 4-hour minimum? So if this state law is adopted, it trumps all of those provisions, so that you could very well have employees who say, I want to take a 1-hour increment to go get my prescription filled. I don't care if it's going to break down a DPW crew and you're not going to be able to send them out. You can hire someone on a 4-hour minimum. And so this is also a brand new area of law, and it is yet to be challenged in the courts, and we expect that it would be. So we decided to be proactive because the town residents voted overwhelmingly to adopt this type of a law on the state level, and we decided to implement it for our less than part-time and temporary employees. I think that's it.
Thank you. Mr. Farlow, why don't you sit in the front row in case we have other questions for you?
Good evening. My name's Frank Farlow. I'm a Precinct 4 town meeting member, and I'm speaking as co-chair of Brookline PACS in favor of the petitioner's motion. First, it's clear to us that in several respects, as outlined in the recommendations we sent to you in the mail, that the state law would provide stronger protections for our employees than the town's current policies. Second, we expect that wrinkles in this area can be worked out over time in union negotiations without the severe difficulties currently being forecast. Third, the town's unions are not worried about the difficulty of the negotiations. The teachers and fire unions and AFSCME have all endorsed the resolution. This was not the case last fall when we considered this issue. And fourth, other things equal, it's our view that fairness to town employees should be weighted more heavily than convenience to the town. In the November 2014 state election, most of us voted to provide precisely these protections for most private employees throughout the state. We recommend favorable action on the petitioner's motion to provide them now for all our town and, hopefully, school employees as well.
Mr. Clafter?
Yes, David Clafter, a town meeting member, Precinct 12. I'm speaking as someone who, until a very recent retirement, served as senior management in a medium-sized local employer, a private employer, and also as someone who in my previous careers has served as a chapter leader and been very active in union negotiations. And I just want to point out that virtually every objection that's been raised to this could equally be raised by private employers, many private employers. In fact, each private employer understands their own special needs very well and understands how it would be convenient not to be bound by a state regulation. Nevertheless, the citizens of Brookline and the citizens of Massachusetts voted overwhelmingly to bind all those private employers to this new law. And I think from the standpoint of just equity, that we're told by implication that really there's not very many people affected by this. The costs of this are relatively minor to implement. And we're told that for convenience sake, it would be nicer not to have the town covered. I think that for equity and fairness sake, it would be very nice to have town employees covered. Further, I think the union argument is, the union contract argument is a red herring. There's been an attempt to conflate personal days and sick days in all the discussions. In fact, virtually every union and non-union employer I've ever had has had personal days. The question, or a personal day, some number. The fact that union contracts might provide better benefits doesn't mean that you've given away the store in the negotiations when all of a sudden they can use their sick days for preventative care. In fact, I think that's a very reasonable kind of provision. So I urge you to support this. Thank you.
Thank you, Ms. Stone.
Mr. Moderator, Rebecca Stone, town meeting member from Precinct 3. I just wanted to clarify for people who don't necessarily remember the debate last November over Warrant Article 7. The school committee's position then and continues to be that we support the idea of earned sick time for less than half-time temporary and certified seasonal employees. The issue is not with our support for that sick time. The issue is with the coverage if we adopt this law for people who are in fact not short-time employees the way people typically think about them and the way that was just described. So the policies that have been passed by the town, that was the policy that was also passed by the school committee that will be implemented, covers our long-term substitutes, which when we spoke with petitioners in November and again this spring seemed to be the main focus for the schools was the long-term substitutes. We completely agree. The school committee wanted to cover those long-term substitutes and they will now be fully covered with sick time. The short-term substitute issue is very different. A short-term substitute is hired on a per diem basis. They are called when a teacher is out. If they can't make it that day, they say no. If they can make it that day, they come in. The idea that we would be collecting information on their hours raises them to a level of administration that we do not currently have in place that would be in fact burdensome, and it also allows the possibility, however remote, that someone who is a short-term substitute would be called to replace a teacher who is out sick, would then say that they can make it, and then say that they can only make it for a certain number of days because they are taking an hour, 2, or 6 of their sick time that's been earned. And we would then be in a position of having to hire yet another substitute to cover for the time that that substitute would be out on sick leave. I think paying for 3 people to do the work of 1 is not what this law intended, and it's certainly not it's not a logical way to implement it. The policy that we have implemented would cover everybody. All it does is exempt certain employees, stipendiary employees, people like coaches who are not otherwise employed by the schools, public schools of Brookline, student interns in our offices, and these short-term substitutes, among others. I think everybody here can recognize that the sick leave law is not intended for those positions. We would in fact have to cover them should the law be adopted. Our policy covers the people who should be covered. We are in favor of that policy and in favor of giving sick time to those employees.
Thank you, Mr. Levy. Welcome back.
Thank you. Mark Levy, Precinct 7. I think the big issue here for me is a matter of who has the dignity and who has to be Oliver Twist and who gets to dole out the porridge. I say that it's about, to me, the key question here is who gets to be Oliver Twist and who gets to dole out the porridge. The big difference between the town policy, or one of the big differences, is that under the town policy, administrators get to say yes or no as a favor to the employee. Under the state law, the employees have earned sick time, and they get to take it within certain limitations, and it's theirs by right. They're not asking for a favor. They're not asking for a handout. They're saying, this is something I need for my family, for my health, my child's health, my elderly parents' health, and I don't want to be in a position where I have to choose between missing a day's pay or 4 hours pay, or having to go to the department head and plead my case. I want to be able, as an employee, to say, this is what I've earned. And there's provisions in the state law that says that, you know, there are some reasons why a state employee might be denied a covered employee might be denied the benefit for an urgent need. But that's not what we're talking about here. We're talking about the principle of who is the human being, who is the dignity of the workplace, who has the right to have the same coverage as private employees throughout the state have been given by the state. And I think that's, in that level, I have to urge that you vote favorable action under this article.
Thank you, Ms. Carroll. And Ms. Wender-Schubo, would you come down and sit in the front row, please?
Carroll, Precinct 10. Last fall, when this warrant article was before the town meeting, I voted in favor, or I encouraged people to vote in favor of no action. Once again, this spring, when the warrant article is here, I'm also encouraging people to vote no action. I've spent a lot of time between last November and this spring looking at what's going on. I've attended any number of meetings, I've interviewed some part-time employees, and I think what Brookline has done is something that we can be proud of. There's no other, as I think Janet referred to in her presentation, the only other town or municipality that has done anything is Concord, and it's nowhere near what Brookline is proposing and is doing currently. I think being the first to do things, Brookline likes to do that. But I think when it has to do with being the first to attempt to deal with the state law, I think I would rather sit and watch some other people try that out first. I wouldn't say that if we hadn't done anything to help our part-time employees. And I think we have, and I think we're doing a good job. We're giving them, and I disagree with Mr. Levy saying that people have to negotiate to get their sick time. If they have accrued sick time, they can use it. The one piece that he might be correct in saying is that some departments might say you have to take half of your sick time, where others are able to say, no, we can adjust our schedule. And I think that would be the same with the state law. So at this point, I think we're only 6-7 months into this, and I think we should play it out some more and see what's going on. There's nothing that would stop us in the future from adopting the state law, but at this time, I think that Brookline is doing a good job, and we should support it, so I encourage you to vote no action.
Ms. Wonder-Schubo.
Good evening. I'm a daughter of Brookline. It's an honor to be here. I went into the voting booth with my dad when he was voting for town meeting members as growing up.
Well, let's hear who you are, please. Would you give us your name, please?
My name is Jessica Wender-Schubo, and I'm speaking as a social studies teacher in the department here in the high school, but also representing a unanimous vote by the representatives of the teachers in every building and every department asking you to support this warrant article. I want to just share with you my experience of a guy named Robert Levine. He has for 11 years come into this building here and served as what Ms. Stone called a per diem sub. He is here every day because he is chosen well in advance by the teachers who know that he understands what the courses are, what the curriculum is, who the students are. He's beloved by the students. He is knowledgeable and skilled and effective, and he earns about $100 a day for making himself available as a contingent labor. Just like you picture people standing up waiting along the roadside, hoping that somebody will give them a day's wages. But Robert Levine has dedicated himself to this district. And I saw him yesterday hanging out, talking to some students, and I'm telling you, he is a pivotal figure in this building. Now, there aren't many people that would earn this sick time. This is a question of dignity. It's a question of actually rewarding those people who are in a position to have made themselves available to teachers who hope they will come in and do the kind of work that he does. You know, we hear a lot about data-driven policy, and I'm asking you to vote for something where the data actually helps the powerless for a change, where it can really be made. I think that we've got the technology to do it. This is an economy that is rapidly turning people into Uber drivers, and here's an opportunity. The voters asked you to do it. The tide is turning. You've heard people here tonight talking on behalf of people who are marginal without the support of institutions. The teachers of Brookline are asking you to support these non-union laborers. It is an act of solidarity with members of this community. And I think Brookline can make its mark. I wouldn't look to other towns. I was always told Brookline can go out in front, not to find the easiest way, but to find the right way. And I would love to be able to go back to the teachers of this community and say that you stood up for the folks they work side by side with, who have absolutely no rights and barely a living wage. So thanks for that.
Mr. Moderator, point of information.
You have a question, Mr. Jones?
Yeah, I have a question that puzzles me, because it's my understanding that part-time employees in the town of Brookline are not represented by any union. So therefore, they must not have a contract. So when people talk about violations of union contracts, I'm a little bit puzzled, because the part-time employees, if this article passes, would be subject to the state law. But there's no contract. They have no contract.
Yes, I think we're all aware of that. Is that correct?
What's that?
We're all aware that this
Okay,
this motion does not apply to.
People say it's a violation of a contract.
Well, I don't think I've heard quite that. In any case, we have a motion for the question. I have one more speaker, Ms. Nobriga, who would speak in favor of the petitioner's position. However, I will allow the motion for the question, which requires a 2/3 vote. Those in favor of terminating debate, please raise your hands. Those opposed, motion. Those in favor, opposed. It's not a 2/3 vote. Ms. Nobriga. And after Ms. Nobriga, I have no other speakers, no one at the microphone, so we won't need to have a motion for the question if all goes well. Ms. Nobriga.
Thank you. Thanks for voting. Good evening. My name is Mariah Nobriga. I'm a town meeting member from Precinct 4 and a member of the Advisory Committee. Though not speaking on, is that okay? Good. Though not speaking on behalf of Advisory Committee. I'm here to speak in favor of Article 14 tonight. First, I want to thank the petitioners for continuing to promote the welfare of town employees, particularly those employees who are not full-time or covered under union contracts. I also want to thank the town for having taken initial steps towards parity in its treatment of our part-time workers, but I would argue that what has been done so far is not enough. I was one of the minority of advisory who voted in favor of this article, and I voted in favor for several reasons. In addition to the obvious benefit of sending a clear signal to Brookline workers, particularly the part-timers, that they are valued contributors to our town, I'd like to focus on 2 points. The first is use of union contracts and definitions of sick time as excuses for not adhering to the earned sick time law. In the Advisory Committee hearing on Article 14, we heard from HR Director Mr. Bowe that there is a discrepancy between how sick time is defined in town policies and particularly how it is defined in the union contracts and this law. The town policies say you or a family member actually has to be sick to use sick time, but allows for up to 8 hours of earned sick time to be used as personal time for well care. And the law allows for up to 40 hours of the earned sick time to be used for wellness care. For those who don't know, wellness care is things like going to the doctor to get vaccinated, routine physicals, or to follow up on chronic conditions such as diabetes and arthritis. First off, this discrepancy is not actually a problem. The law already accounts for this and says in the event of a discrepancy, the more extensive policy binds. And you've seen in your handouts and heard earlier tonight that 3 of the town's unions support this article. More broadly, I think Mr. Bowe is trying to imply that the law is incompatible with union contracts. Go tell that to the numerous private employers who have unionized employees and are already complying with the law, as so many of us voted in favor for them to do last year. In short, this is an insufficient justification why we shouldn't adhere to the law. Now let's hear a good reason why we should adhere to the law. Use of sick time for well care. One of the most important differences between the town's current policy and the law is this question of whether sick time allows for wellness care, which I mentioned earlier. Again, the town's current policy only allows for up to 8 of the earned 40 hours to be used for wellness care, while the state allows for all of the 40 hours to be used for wellness care. While many people may think that the town is saving money by making sick time only used for sickness, there's abundance of evidence that wellness care programs actually save significant amounts of money. A Harvard Business Review article describes the case of Johnson & Johnson, which saw a return of $6 for every dollar spent in wellness care due to increased productivity. The HBR report further states, a variety of studies confirm the health conditions that contribute most to lost productivity: depression, anxiety, migraines, respiratory illnesses, arthritis, diabetes, and back and neck pain. These are all chronic conditions. They're all best treated through well care so that they do not reach the point of sickness. Further supporting this case for the savings from wellness, a report from the top journal Health Affairs showed in a meta-analysis of over 100 wellness care studies that medical costs fall by about $3.27 for every dollar spent on wellness programs, and that absenteeism costs fall by about $2.73 for every dollar spent. So again, that is a 6-to-1 return on investment for wellness programs.
You have 1 minute.
The Advisory Committee majority report states that the vote to not adopt the earned sick time law is a question of fiduciary responsibility. However, given the positive financial impact of well care on the bottom line, as well as the increased quality of life it can provide for town employees, it is a fiduciary and social responsibility to vote to adopt the earned sick time law. I urge you to vote in favor of Article 14 tonight to improve the health of both our town employees and the town budget. Thank you.
Thank you, Mr. Wyszynski.
Thank you, Mr. Moderator. Neil Wyszynski. I just want to make a few points. One, Mr. Levy mentioned that without this, we're doing the employees a favor. That we need to pass it so we don't have to do the employees a favor. I'll say that sick leave now is a right. We've established a policy. Employees earn their sick leave, and it's a right. The sick leave policies apply to everybody, not just part-timers. It applies to everybody. If we pass this law, it applies to everybody, and most of the employees are full-time, and they're covered by the union contracts, which are more generous than the sick leave law. Lastly, I'll say that we can pass this at any time, and I'll just agree with Carroll. We can pass this any time. We have this is But if we do pass it, there's no turning back. So let's be careful, let's be prudent, and I would urge a no action.
Ms. Gilman.
Thank you, Mr. Moderator. Jane Gilman, Precinct 3, with a question about procedure. Is there a time standard for reintroducing the same warrant article?
No,
Thank you.
except with respect to zoning zoning amendments. There's if a zoning proposal is turned down, there's a 2-year period during which it cannot come back before us without planning board approval. But this could come back each town meeting.
Thank you.
On the motion on the of the petitioners on supplement number 1, it's a 3-line motion that the town accept the provisions of Chapter 148C of Chapter 149. Yes?
May we have a recorded vote, please?
If there are 35 town meeting members who want a recorded vote, we will have one. It will be done by ballot, not, unfortunately, by electronic vote. There are 35 town meeting members who wish a recorded vote. I have appointed tellers, and the tellers will now pass out ballots. The town meeting members will kindly fill out the ballots and then return them to the tellers. As you will see, the ballots call for a date. Today's date is the 31st of May. Article 14 that calls for the article, and it's Article 14. And the motion is main. Doesn't matter, it's the only motion before us under Article 14. You're asked to print your name, enter your precinct, and sign the ballot, and of course, circle either Y for yes, N for no, or A for abstain. It's a fairly simple ballot, and I hope that you don't have any difficulty with it. Oh, yes, the selectmen normally vote with our service by the tellers on the right, is that correct? Okay.
Mr. Moderator? Mr. Moderator?
Yes.
To your left, and everyone else is right.
Yes, Mr. Rosenthal.
Yeah, thank you, Marty Rosenthal again, Precinct 9. As you do with electronic votes, do you care to take a standing vote first?
Nope.
Thank you. Or no thank you, or whatever.
Ms. Khan, you and Mr. Friedman are on my right.
Yes, I'm only handing out the ballot.
Okay. And you're also responsible for making sure that the Board of Selectmen have ballots. They also have a vote here.
Mr. Moderator,
Yes.
what are we supposed to do under motion? I've got two things.
Well, you can put down main or put down nothing. As long as you've got Article 14 entered, we know what motion it is. But you can enter the word M-A-I-N on next to motion, if you wish. Is there anyone without a ballot? I suggest to the tellers that you collect the yes votes first and then the no votes so that it will make it easier for you to count them, but the tellers are doing what they, yes, they're collecting all of them. They'll sort them out, Mr. Town Clerk. Once you've completed your ballot, would you pass it to the person in the aisle nearest to you? After the tellers collect the ballots, they have to sort them out. They will then report their findings to me, and I'll announce the results of the vote. tellers are now collecting the ballots, so make sure that you turn them in. You are, ladies and gentlemen, witnessing one of the great advantages of electronic voting. This is a pretty tedious process. Well, it doesn't matter. Turn your ballots in anyway. If you see a teller, give them your ballot. And when the tellers are ready to report, would one of them please come to the microphone and signal that you're ready? Mr. Friedman on the right and the selectman.
10 votes yes. 39 no.
10 yes, 39 no. Any abstentions? Well, you can tell us about abstentions later.
No.
No abstentions. And once you've announced your tally, please turn the ballots into the town clerk.
Mr. Moderator, from the center section, 35 yes, 34 no, 1 abstention.
35 yes, 34 no, 1 abstention. That's in the center. Mr. Farlow? (44) in favor, 21 against, and 6 abstentions. On the left, it was 44 in favor, 21 opposed, and 6 abstentions. Motion fails by a vote of 89 in favor, 94 opposed, and 7 abstentions. Article 15. We turn now to Articles 15 and 16, which will be debated together. And since they involve exactly the same subject matter, which is the Carlton Street Bridge, which has a tangled and difficult history with town meeting, but these articles, could we have quiet, please? These articles are apparently non-controversial. Each requires a 2/3 vote. The motion under Article 15 is on the Lavender Supplement, pages 10 through 13, including the maps. Moved by Mr. Franco, seconded by Mr. Brown. The motion under Article 16 is on the red supplement, page 1. Moved again by pages 1 to 3, again including the 2 maps. Moved again by Mr. Franco and seconded by Mr. Brown. Mr. Franco. Each of these requires a 2/3 vote.
Thank you, Mr. Moderator, and through you to the body. I am Ben Franco, speaking for a unanimous Board of Selectmen. I stand before you to present the Board of Selectmen's unanimous recommendations for a vote of favorable action on what amount to 2 housekeeping articles. Both articles I will speak to, Articles 15 and 16, concern the acquisition of temporary and permanent easements necessary to advance the rehabilitation of the Carlton Street footbridge. Article 15 addresses easements that must be acquired from the town of Brookline. Article 16 concerns easements from the City of Boston and the Massachusetts Department of Transportation. Passage of the articles is necessary to allow the Carlton Street footbridge rehabilitation project to proceed with outside funding. A quick word about the history of the Carlton Street footbridge and town meetings' discussions of it. Many town meeting members will remember the frequent debates this body has had about the footbridge and more broadly about the Muddy River Restoration Project. Perhaps the only topic more frequently debated in recent memory is pay-as-you-throw, and in a fitting tribute that this body discussed that article earlier this evening, or earlier this town meeting, I should say. The Carlton Street footbridge is a pedestrian bridge that was built in 1894 and that is owned by the town of Brookline. The bridge, however, has been closed since approximately 1976. The Carlton Street footbridge spans the tracks of the MBTA's Green Line D branch connecting Colchester and Carlton Streets, as well as the Carlton Path with the Riverway Park. In 2009, town meeting committed to funding the rehabilitation of the bridge if outside funding could be obtained. The town's commitment came, at least in part, against the backdrop of a requirement by the Commonwealth of Massachusetts that Brookline commit to restoration of the footbridge if the state's commitment to the larger Muddy River Restoration Project was to be maintained. Tonight's vote is the final step the town must undertake to allow the bridge to be restored and to fulfill the requirement the Commonwealth has placed upon us. In recent years, the funding sources that will be tapped to restore the bridge have become much clearer, and I'm happy to report the town meeting's 2009 funding authorization is now largely unnecessary. It is expected that 80% of the rehabilitation cost will be borne by the federal government, with the remaining 20% the responsibility of the Commonwealth of Massachusetts. Should the expected funding arrangement be achieved, and it is very likely that it will be, the town's only responsibility will be to cover the cost of obtaining the necessary easements and completing final design, something that's already been contracted. We are here tonight to deal with the easement issue. The acquisition of temporary and permanent easements for a project of this type is not unusual, making passage of these 2 articles largely housekeeping matters. Easements are required for this project both to allow construction activities to proceed on town, City of Boston, and MBTA property, and to receive the necessary permissions to allow the renovated bridge's footings, stairs, accessible ramps, and pathways to exist on town, city, and state property. Given that the easements that would be required under Article 15 are with ourselves, the town of Brookline, there is not expected to be a cost associated with acquiring them. The town hopes that the acquisition of easements from the City of Boston and the State Department of Transportation, the MBTA, will either be free or carry a minimal cost. Should there be a cost to obtaining these easements, the $1.4 million the town meeting authorized in 2009 would be utilized. The Board of Selectmen unanimously recommends a vote of favorable action on Articles 15 and 16.
Mr. Brown and Mr. Schramm, would you come forward, please, and sit in the front row?
Cliff Brown, Precinct 14, speaking on behalf of the Advisory Committee. By a vote of 17 in favor, no opposed, no abstentions, the Advisory Committee recommends favorable action on the motion offered by the Board of Selectmen. Thank you.
Mr. Schramm, are you in the auditorium?
Both of them.
On the motion under Article 15 and the Lavender Supplement, pages 10 through 13, those in favor, please raise your hands. Those opposed? Motion carries unanimously. Article 16, the motion on the red supplement, supplement number 1, pages 1 to 3. Those in favor, please raise your hands. Those opposed? Motion carries again unanimously. If 10 years ago you ever thought you'd get a unanimous vote on the Carlton Street footbridge, you would have been institutionalized. Article 18. Motion under Article 18 is on page 18-2, moved by Ms. Connors, seconded by Ms. Heller, that the town adopt the resolution set forth on page 18-2 relating to St. Aidan's Church. Ms. Connors.
Thank you, Mr. Moderator. Patricia Connors, Town Meeting Member, Precinct 3. On January 20th, 1961, President Kennedy began and ended his inaugural address with references to God. His opening, quote, "We observe today not a victory of party, but a celebration of freedom, symbolizing an end as well as a beginning, signifying renewal as well as change. For I have sworn before you and Almighty God the same solemn oath our forebears prescribed nearly a century and 3/4 ago. The world is very different now, for man holds in his mortal hands the power to abolish all forms of human poverty and all forms of human life. And yet the same revolutionary beliefs for which our forebears fought are still at issue around the globe. The belief that the rights of man come not from the generosity of the state, but from the hand of God," end quote. And then his closing, quote, "And so, my fellow Americans, ask not what your country can do for you, ask what you can do for your country. My fellow citizens of the world, ask not what America will do for you, but what we together we can do for the freedom of man. Finally, whether you are citizens of America or citizens of the world, ask of us here the same high standards of strength and sacrifice which we ask of you. With a good conscience, our only sure reward, with history the final judge of our deeds, let us go further to lead the land we love, asking his blessing and his help, but knowing that here on earth, God's work must truly be our own," end quote. Interestingly, during the advisory committee's deliberations on this warrant article, there was a suggestion that town meeting's adoption of this resolution would violate the doctrine of separation of church and state. On September 12, 1960, during his presidential campaign as a Catholic candidate, Kennedy noted, "I believe in an America where the separation of church and state is absolute, where no Catholic prelate would tell the president, should he be Catholic, how to act, and no Protestant minister would tell his parishioners for whom to vote, where no church or church school is granted any public funds or political preference, and where no man is denied public office merely because his religion differs from the president who might appoint him or the people who might elect him. I believe in an America that is officially neither Catholic, Protestant, nor Jewish, where no public official either requests or accepts instructions on public policy from the Pope, the National Council of Churches, or any other ecclesiastical source, where no religious body seeks to impose its will directly or indirectly upon the general populace or the public acts of its officials, and where religious liberty is so indivisible that an act against one church is treated as an act against all. St. Aidan's was the church where our 35th president was baptized and instilled with his religious training during his early formative years. It happened to be a Catholic church, but whether this place of moral teaching was Catholic, Muslim, Protestant, Jewish, or secular is irrelevant. The St. Aidan's site is truly historic, and town meeting should be free to affirm its historic significance.
You have 1 minute.
I'd like to thank some of our local citizen activists who contributed to the preservation of the church building and its adjacent landscape, including the centenary copper beech tree. The recently departed former town meeting member Eleanor Bart, a champion for preserving as much of St. Aidan's as possible, including the exquisitely beautiful interior, which provided a singular sense of spirituality, but which we unfortunately were unable to save. Diana Spiegel, chair of the campaign to preserve St. Aidan's. Many an evening our members spent in her and her husband Stanley's living room, strategizing our next plan of action. Diana provided calm leadership throughout that long, stormy campaign. Craig Boland, who
you need to conclude, Ms. Connors. I suggest that you just read the names of others you'd like to pay tribute to, and not their role in this process. Thank you.
Very good. Craig Boland, Regina Frawley, Bill Powell, Peg Centuria, Roberta Winitzer, Betsy DeWitt, Francis Shedd Fisher, Jean Stringham, Myra Harrison, the superintendent of the JFK National Historic Site. I urge you to vote yes on Warrant Article 18 to affirm the historic significance of the St. Aidan's site and to support the recent installment there of a historic plaque which will aid visitors in their understanding of the St. Aidan's chapter and the development of an American leader who inspired the world. Thank you.
Thank you, Ms. Heller.
Nancy Heller for unanimous Board of Selectmen. The members of the board are very much in support of this resolution. We're pleased, very, very pleased, that the plaque noting the historical significance of the St. Aidan's site has already been installed. And we are also pleased that the petitioner was able to present a revised article asking for affirmation of the historical significance of this site. This resolution gives us, town meeting, and the citizens of Brookline an opportunity not only to acknowledge publicly our support for the installation of the plaque, but also to recognize the historical and architectural significance of St. Aidan's, so that generations to come will have a better understanding of our history and our lives. I urge you to vote favorable action on the resolution on page 18-3. Thank you.
Thank you, Ms. Lodish.
Pam Lodish, Town Meeting 14. By a vote of 12 to 9 to 2, the advisory committee recommends favorable action on the motion offered by the selectmen.
Mr. Richmond.
Clint Richmond, Precinct 6. Since it's already installed, I'm just curious how much this cost.
How much it, I'm sorry?
How much did the plaque cost?
Does anybody know? Seems to me that horse is out of the barn, Mr. Richmond. On the if you're responding to Mr. Richmond, would you please come to a microphone and do so? Sorry.
It didn't cost the town anything. It was done by the people who built the buildings.
Thank you. On the motion on page 18-2, those in favor, please say aye. Aye. Those opposed, no. Motion carries unanimously. Article 20. We've already disposed of Article 19. Article 20, the motion offered by the petitioners on the Gray Supplement, pages 1 and 2, relating to the sovereignty of the Cuban nation. Mr. Miller is the petitioner. He's not a town meeting member. Would someone please move the motion on the gray supplement? Is there a second? It's moved and seconded. There is an amendment, I think. It's found on the orange supplement. The under the Board of Selectmen write-up, the orange supplement, pages 1 and 2. It's moved by Mr. Green, seconded by Mr. Lynn Jones. I'm not certain how the two motions before you differ, but you'll undoubtedly get an explanation of that. Mr. Miller. Okay, I certainly will.
Good evening, everyone. I'm Peter Miller. I am a former town meeting member from precincts 8 and 11, and I'm pleased. Okay, I'm Peter Miller, former town meeting member from precincts 8 and 11, and pleased to be here in moving the article by petition as the main motion. And in doing so, I want to underline 3 points in this call for an end to the embargo against Cuba and respect for Cuba's sovereignty. I want to point out our areas of agreement to end this long-term mistake in major foreign policy, and then point out the two matters at issue. With regard to the call for an end to the embargo, we are all in major accord. The joint report cites a recent Gallup poll showing 59% of the American public in favor. Actually, this was from early last year. More recent polls show even higher figures. 73% of all Americans, 59% of Republicans alone. From amongst the selectmen and the advisory committee and the 50 to 60 people I spoke with, figures are even substantially higher. Expressing our support, along with that of other localities, can undoubtedly contribute to its eventual end. And here we come to the first point at issue, the references to specific federal bills that do precisely this. References whose removal is argued for, since legislation is often long and complex, can contain hidden riders, and the selectmen had no opportunity to review it. Point well taken. We should look. And in fact, it's easy to do at congress.gov. And if you do that, what we find here is the absence of any riders and amendments and bills of record shortness, according to the advisory subcommittee, from 23 to 82 lines. That is a quarter of a page to slightly over 1 page. Bills that essentially remove presidential prohibitions on travel in one case and delete export restrictions from existing laws in the other. These are bills that do precisely what they purport to do and are the direct legislative links between the local resolution and the federal action they point to. There is no reason not to be specific about them, is there? More serious is the second deletion that calls for a response and objection. The original petition notes the existence of covert regime change, that is democracy promotion, operations by the U.S. Agency for International Development, USAID, and calls for their disavowal and the end of support for them. Statements of fact and condition as clear as those that support the call to end the embargo. For some reason that is still unclear to me, the advisory committee chose to eliminate these sections altogether and did so originally in all of one sentence that reads as follows. Members felt that covert operations, whether they exist or not, are necessarily secret and cannot be evaluated or condemned. This claim is mistaken in each of its 4 parts, and I came to town meeting last Thursday prepared to respond to each of its parts, only to find a supplement that responded to a second discussion that was held. Here the confusion is not so succinct. It is spread over 3 to 4 paragraphs in this orange supplement that reflect a profound misunderstanding of what USAID covert operations are. Here, there is no denial such programs exist, but rather, since they've been so clearly reported on, quote, it is something of a misnomer to call them covert operations. Furthermore, they are like assistance that has been sent to families of Cuban political prisoners. This is just false and confusing. Let me clarify why this is so by offering brief, one-sentence summaries of 3 recent examples. The first was an operation that was planned in the mountains near Barcelona and involved channeling $1.6 million secreted in offshore accounts to establish Zunzuneo, Cuban slang for a hummingbird's tweet, an imitation Twitter application, and distribute it to 40,000 Cuban cell phone users whose numbers were in fact stolen, all done to inspire them to organize smart mobs to trigger a Cuban Spring uprising against the government. Another story involved a complementary program led by Alan Gross, who had repeatedly brought in explicitly illegal internet broadcast equipment, whose arrest was declared by U.S. officials to be that of an innocent humanitarian merely helping distressed communities in Havana develop communications resources, and who, a week after his release, received a $3.2 million settlement that USAID's press release noted, quote, avoids the cost, delay, and risks of further proceedings and does not constitute an admission of liability by either party. Finally, I note the USAID project with Creative Associates International, a Washington, D.C. corporation run by a Serbian contractor who used a Panama front company and a bank in Liechtenstein to fund and secretly infiltrate Cuba's underground hip-hop movement, recruiting unwitting rappers to spark a youth rebellion against the government. Does anyone really want to argue these embarrassing, foolish, questionably legal, and ill-advised operations are not covert just because we found out about them, or that they're like aid sent to families of political prisoners? To call for an end to these kinds of programs is as sensible and reasonable as the call to end the embargo itself. Please join me and vote for the full petitioner article. Thank you.
Thank you, Mr. Green. And if John Le Carre is in the auditorium, please come forward.
Mr. Moderator, Bernard Green for the Board of Selectmen. Warrant Article 20 calls for an end to the economic boycott by the United States of Cuba, which is an embarrassment and a relic of the Cold War. It originated under President Eisenhower in 1960 and was expanded under Brookline's own John F. Kennedy by legislation during his term. The board supports the notion of lifting the embargo. However, we do question whether it's appropriate to include specific pieces of legislation in the resolved clauses of this article. I don't think that we address the issue of the covert actions, which is part of the recitals and just background information. In the resolved articles, or resolved provisions, there are a list of 3 pieces of legislation without any explanation of what this legislation is all about. As the previous speaker mentioned, it would be very, very easy for someone to go to the congressional website and read the legislation. There are only 3 pieces and very short pieces at that. but it's legislation that has only been introduced into Congress. There's plenty of time for amendments or devilment of one sort or another. But I think, you know, the Board of Selectmen's concern is that as a matter of principle, when we mention pieces of legislation in a warrant article, we should provide town meeting with some background information so that we are voting on the basis of information, not just opinion or assertions that have no foundation necessarily. I think, you know, if that had been provided, we probably would have supported the inclusion or at least reference to the legislation. But, you know, in the future, when pieces of legislation are referred to in a warrant article, it really would make a lot of sense to include information so that people can act on that. So the Board of Selectmen, by unanimous vote, recommends favorable action on the motion on warrant Article 20 as amended by the Advisory Committee, and urges town meeting to vote favorable action also. Thank you.
Before we hear from Mr. Sandman, I correct the vote under Article 14. The yeses and nos remain the same, 89 in favor, 94 opposed, but there are 2 more abstentions, a total of 9, since the town clerk and myself, in our zeal, failed to fill out ballots during the voting. We've now done so, so it's 89, 94, 9 abstentions. Mr. Sandman. You aren't going to drink that.
Not here, sir. I won't tell you how full it was before town meeting started.
Let us know who you are, sir.
Mike Sandman speaking for the Advisory Committee, the chair of the school subcommittee, which naturally picked up the Cuban trade embargo article. Article 20 puts Brookline on record as being opposed to the continuation of the embargo on trade with Cuba. The Advisory Committee voted 13-3 with 3 abstentions to recommend favorable action on an amended version of Article 20, and 10-4 with 2 abstentions to recommend the amended version subsequently recommended by the Selectmen. Our full report is on page 20-2 of the combined reports, and it's modified in the supplemental mailing on the orange sheet. Here are the main points. The embargo was imposed 56 years ago by the outgoing Eisenhower administration in an effort to undermine the Castro regime. 20 years ago, a Republican Congress passed the Helms-Burton Act requiring that the embargo stay in place until Cuba holds free and fair elections, releases political prisoners, and guarantees free speech and workers' rights. Only Congress can lift those provisions. The embargo has clearly failed in its purpose, and there's ample evidence that it's the Cuban people who have paid the price rather than the regime. A recent Gallup poll showed that a large majority of the American public is in favor of ending the embargo, and the article was not controversial in our hearings. The main question was whether lifting the embargo would give tacit approval to the Castro regime's oppression of dissent, but if we hold to that standard, we would need to impose embargoes on many other countries, including China and Saudi Arabia, respectively our second largest trading partner and our largest supplier of imported oil. The Advisory Committee made 2 amendments to the original article. We deleted references saying that the embargo was, quote, inhumane and in violation of international conventions, unquote. Embargoes and trade sanctions have been used in attempts to change the policies of countries ranging from North Korea to Iran, and recently to penalize Russia following its seizure of the Crimea. Some of these measures have been supported by the United Nations, so it's not at all clear that the embargo is a violation of international conventions. The petitioner accepted this change. We also deleted references to covert action in order to keep the focus on the trade embargo. The petitioner does not accept this change. Covert action should not be conflated with acknowledged action. The petitioner said that the U.S. Agency for International Development should not sponsor efforts to undermine foreign governments. Okay, but AID supports the families of Cuban political prisoners. Should that stop? And other agencies conduct covert action. For example, we listen in on communications globally. Some of our covert actions are dumb, but should we really cease all such covert action directed against Cuba? Why should Fidel Castro have more privacy than, say, the Chancellor of Germany when she makes a phone call? In their review, the selectmen deleted support for the specific legislation introduced in Congress. The selectmen's view, as Selectman Green said, was that we don't know what the final form of these bills will be. The advisory committee was less concerned, but in the interest of bringing you a single amended article, the advisory committee voted on May 19th to adopt the selectmen's version. One other issue is whether town meetings should be debating matters of national policy. Proponents pointed out that by adopting the proposed resolution, we would be conveying our views to our congressional representatives on a current legislative matter. If you're old enough, as I am, you remember Fidel Castro's 1960s slogan, Cuba si, Yankee no. Tonight, we invite you to discard a Cold War relic. Let's have Cuban rum and really good cigars. Cuba si, Yankee si. The advisory committee recommends favorable action on the amended version of Article 20 as offered by the selectmen.
Now, ladies and gentlemen, I'm going to make an attempt to point out the differences between the advisory committee and selectmen's motion on the orange supplement and the petitioner's motion. I believe they are as follows. If you look at the motion offered by the petitioner on the gray supplement, the last whereas clause on page 1, the first page of that supplement, was not included in the advisory committee and selectmen's motion. The now therefore be it resolved clause at the bottom is somewhat different, and the last two resolves on the page 2 of the gray supplement were omitted from the advisory committee and selectmen's proposal. So we're going to take the motion on the orange supplement as a substitute motion, since it's virtually impossible to treat it as a series of amendments without utterly confusing everybody. If the motion passes, then we will vote on the main motion as amended. That is, we'll have a second vote on the substitute motion of the advisory and the selectmen. If it fails, we will get to Mr. Miller's petitioner's motion on the gray supplements. Any questions? Okay, on the motion on page 1 and 2 of the orange supplement, those in favor, please raise your hands. Those opposed, motion carries. As on the motion, main motion as amended, to wit, the motion that you just adopted, those in favor, please raise your hands. Those opposed, please raise your hands. Motion carries by a majority vote. We now proceed to the last article on the warrant, having disposed of Article 21 earlier. Article 22. The main motion under Article 22 is that of the petitioner on pages 1 and 2 of the lavender supplement, a resolution urging rejection of free trade deals containing ISDS, moved by Mr. Farlow, seconded by Mr. Clafter. The advisory committee offers a motion on the green supplement. The difference between the two, again, is a mystery to me present, but let's hope it's clarified by the speakers. On the green supplement, the motion is made by Ms. Nobriga and seconded by Mr. Lynn Jones. Mr. Farlow and Ms. Nobriga, would you come forward and sit in the front row, please?
Frank Farlow, Precinct 4, speaking as a petitioner and as a co-chair of Brookline Pacts. A couple of decades ago, multinational corporations developed a new type of foreign trade agreement. The first example was introduced to the American public in 1993 after years of development by the Fortune 500's top trade lawyers. NAFTA was a free trade and investment agreement that provided investors, mainly corporations, with a new set of guarantees designed to stimulate direct investment abroad and to encourage the movement of factories within this hemisphere, especially out of the U.S. and into Mexico and Canada. That set of guarantees, the Investor-to-State Dispute Settlement System, or ISDS, has been carried forward in all subsequent major free trade agreements, alongside other contributing factors such as deregulation and privatization, declining rates of unionization and technological change. These agreements have contributed increasingly to the disappearance of manufacturing jobs and the rise in income and wealth inequality in the U.S. The resultant second gilded change, which you all have heard of, has produced the current roiling candidacies of Sanders on the left and Trump on the right, with assuredly more yet to come. It's for these reasons that we felt it important to introduce our resolution with a single whereas clause that solidly set forth the context in which the Trans-Pacific Partnership is being introduced. It's primarily the presence of that clause to which the Advisory Committee objects. We feel it provides the fundamental clarity to the resolution as a whole. The TPP is not just the most recent in a line of major trade agreements that incorporate ISDS. It's the biggest agreement to date, representing 40% of the world's economy. And it would not only include ISDS, it would substantially expand it, newly empowering nearly 10,000 foreign corporations and subsidiaries to seek cash compensation from U.S. taxpayers by challenging government laws and court rulings before foreign tribunals whose rulings can't be appealed on the merits. In one of the quotations we cite in our additional explanation on the yellow-green pages in the supplemental mailing, leading legal experts, including Harvard Law's Lawrence Tribe, strongly criticized the inclusion of ISDS in the TPP, warning that, quote, ISDS is antithetical to the fair, public, and effective legal system that all Americans expect and deserve. In another quotation, our own Senator Warren concludes by saying, if a final TPP agreement includes investor-state dispute settlement, that's ISDS, the only winners will be multinational corporations. 9 other Massachusetts communities have already adopted resolutions in roughly the same format as our long original version. But at the strong urging of the Advisory Committee's subcommittee, we eliminated 5 of the original whereas clauses and reduced significantly what is commonly referred to within the Advisory Committee as inflammatory language. Then, at the urging of the Advisory Committee as a whole, we deleted 2 more whereases. But we chose to leave the first whereas intact, even if its language, like Senator Warren's, may strike some as more inflammatory than factual. We encourage you to join with us and with PACS and the Selectmen by voting no on the Advisory Committee amendment and yes on the main motion. Thank you.
Well, I am still at a loss as to what the difference is between the 2 motions. So, sure. Would you please? The first whereas clause in each of the things I'm looking at are exactly the same.
I think if you, I'm Sean Lynn Jones, Chair of the Advisory Committee. I think if you look at the supplement on the green sheet, there is a strike-through that distinguishes the advisory committee amendment, essentially. Yeah, on page 7, the first and the second whereas clauses are deleted, as is one part of another whereas clause. And you can see through the strike-through that those are deleted, whereas they are in the petitioner's motion. If you look at page 8 of that supplement, you'll see a minor change in wording that I don't think changes the meaning, but arose because TPP had already been spelled out in the way that the advisory committee amendment structures the whereas clauses. So it didn't have to be spelled out. It could just be TPP.
All right, the advisory committee motion is on pages 7 and 8 of the green supplement, and it does indeed strike the first whereas clause. Ms. Nobriga. Apologies for my confusion.
Thank you. Mariah Nobriga on behalf of Advisory Committee. Advisory voted 10 in favor, 2 opposed with 5 abstentions for favorable action on Article 22, the amended version, as you see exactly on the greenish yellow sheets, pages 7 and 8 and 9. And the principal difference, as was just alluded to, is the very first paragraph, which isn't really germane to the actual topic of the resolution. The title of the resolution, which was not the original title but was subsequently clarified by the petitioners, is Resolution Urging Rejection. This is on page 1 of the green thing, the supplement. Resolution Urging Rejection of Free Trade Deals Containing ISDS, which is this, now I can't remember the name of it, investor to state dispute process. And so, I'm sorry, investor to state dispute settlement process. And so the really key part is, do you believe that that paragraph actually speaks to the topic of the resolution? Whereas U.S. trade deals over the past 25 years have been corporate-driven, incorporating rules that skew the benefits of their results to corporations and individuals with great wealth and influence, while requiring working families and society at large to bear the brunt of their costs, such as job loss and spiraling income and wealth disparities. And I think a lot of the discussion is that, as Frank mentioned, perhaps advisory construed it as inflammatory, but also trade deals are complex and we don't necessarily know all of the consequences of them. For example, while there are working families here in the U.S. who might have a poorer quality of life, there are working families outside of the U.S. who might have jobs because of this. And so because of this sort of lack of clarity about how exactly that this would A, relate to the resolution, and B, actually be factual, advisory voted to strike it. And so with that, I'd like to, again, recommend that everyone vote by a vote along with the advisory committee, which is favorable action on the advisory committee motion under Article 22. Thank you.
Thank you, Ms. Gregg.
Nancy Gregg, Precinct 8. Mine is a brief statement highlighting the dangers of a trade agreement that is currently supported by the administration. In review, the Trans-Pacific Partnership is the latest in a series of trade agreements that have used arbitration tribunals for resolving disputes. Legal experts, including Lawrence Tribe, have documented how these tribunals shift power from democratically elected governments to multinational corporations. Tribe and others had been urging against including these tribunals in the proposed Trans-Pacific Partnership. Unfortunately, under the TPP, the use of these tribunals simply increases very dramatically. Joseph Stiglitz, the Nobel Prize-winning chairman of the Council of Economic Advisors to the President, says that as a consequence of its expanded reliance on the tribunals, the Trans-Pacific Partnership may be the worst trade agreement we have ever negotiated. According to Stiglitz, the tribunals undermine at every level the efforts by our governmental bodies to assure product safety, worker rights, financial regulation, and environmental protections. Even regulations for protecting the planet from greenhouse gas emissions are vulnerable. This is because the tribunals, composed of corporate attorneys and lobbyists, have the authority to block any legislation that is thought to lower a corporation's expected profits. The content of the Trans-Pacific Partnership had been kept secret even from Congress until quite recently. Upon the release of this 6,000-page document, the Sierra Club noted that it included not even one mention of climate change. In the view of environmental activists, quote, a clear sign that this is not a 21st century trade agreement, as some had claimed, end quote. The Sierra Club's analysis also details various ways that the trade agreement would actually fuel the climate crisis. For example, the TPP requires automatic approval of all exports of liquefied natural gas, thus locking in fossil fuel production, thus resulting in more fracking, resulting in greater air and water pollution, resulting in increased health risks. While the TPP may have been a well-intentioned effort not to cede a trade advantage to China in the Pacific Rim area, its provisions are simply too destructive. Economist Stiglitz has stated, quote, in 2016, we should hope for the TPP's defeat and the beginning of a new era of trade agreements. A resolution opposing the TPP is before the Massachusetts legislature. 9 cities and towns in Massachusetts have already submitted such resolutions to Congress and to the President, as have 23 other communities in Maryland, Indiana, New Jersey, Florida, Wisconsin, Connecticut, New York, Tennessee, Minnesota.
You have 1 minute.
Michigan, and Colorado, as the Maine House of Representatives. I trust that Brookline will vote to stand with them in opposing the TPP.
Thank you, Mr. Sandman. And Mr. Clafter, would you come forward, please?
Ms. Nobriga, Mike Sandman for the...
tell us who you are, Mr. Sandman.
Yes, Mike Sandman of the Advisory Committee. Ms. Nobriga mentioned that trade agreements are basically cut both ways in terms of jobs, and I urge you to consider the Advisory Committee's language as focusing on ISDS rather than on trade agreements themselves. I have personally witnessed through my business career the effects of monopolies protected by tariffs in a great many countries, most notably in Mexico and India, in Brazil, and in South Africa, where corporations in those countries actually benefited enormously from the lack of a trade agreement that opened their borders to foreign competition. And I would submit to you that many American corporations have been forced to become more competitive and therefore reduce the cost of what you and I purchase by virtue of trade agreements. It's a mistake to try to make a judgment as to the success or failure of trade agreements within the context of a vote on the TPP. I would suggest to you that it's much more, that there's much more clarity to opposing ISDS per se, rather than adopting the language proposed by the petitioner and by the selectmen, which in effect condemns trade agreements as an ad hominem. Thank you.
Thank you, Mr. Clafter.
David Clafter, Precinct 12. The increasing impoverishment of much of Middle America, the steady replacement of well-paid, often unionized jobs by poorly paid service sector ones, and the increasing flight of corporate headquarters from our country in search of tax havens have all been central topics in our political discourse this past year and have been very destabilizing elements in the current political climate. While these and the accompanying rise in economic inequality have varied and complex causes, the popular perception that the recent spate of trade agreements has played an important role in these developments is very well founded. I won't go through all the statistics, but suffice it to say that estimates of job losses from the first of these agreements alone, the North American Free Trade Agreement, or NAFTA, are around 800,000. Further, these agreements are profoundly undemocratic. Indeed, a main objective of both ISDS and related limitations on control of capital movement and of environmental and workplace regulations is to limit the ability of local populations to take control of their own lives. The negative results of these treaties is not something separate from ISDS, but they're parts of the same whole. Thus, we would include the first whereas clause for context. These deals are negotiated in the greatest secrecy, with much participation by interested corporate parties and very little or none by representatives of working and middle class organizations. They in fact do just what they're intended to do, function as effective vehicles for the transfer of newly created wealth to societal elites. It's no wonder that these agreements tend to be highly popular with governments and economic elites around the world, but far less so among the general population. And it's therefore no surprise that the three remaining candidates for the major party nominations for president should all feel the need to oppose the TPP in their appeals to the broad population for votes. I would also like to point out an unforeseen consequence of NAFTA. By opening the Mexican markets to U.S. agribusiness, Mexico was flooded with cheap American corn. The result was to impoverish and drive off the land millions of Mexican small farmers. Many went to the newly created sweatshops just across the border from the U.S., but many more joined the rising tide of illegal immigration into the U.S. in the first decade of the 21st century. Still others expanded the impoverished pool of the unemployed from which the growing drug cartels recruited. I think it's time to call a halt to new trade deals until we can add a strong dose of sunlight and democratic participation into shaping them. Please vote no on the advisory committee's motion to amend, and yes on the main motion.
Mr. Margolis? And Mr. Fisher, would you come forward, please?
John Margolis from Precinct 7. Nobody ever complains they have trouble hearing me. If I were in Congress, I probably would vote against the TPP. I say probably because I don't really know. And I suspect that few, if any, of us here today really know. Is there a labor economist in the House? Someone who deals regularly with international trade issues? Okay, there's one. Someone who deals with capital flows on a regular basis? There aren't many of us. This seems to me to be an issue which is a textbook example of why representative democracy is a good thing. It's one where, in fact, most of the people don't really know enough to give a knowledgeable opinion. And I hate to say it, but this august body, I suggest, is in that position here. We don't really know enough. A couple of months ago, Paul Krugman, who won a Nobel Prize for economics, said he was a soft opponent of TPP. He's also debunked many of the more alarmist computations of numbers of jobs lost and adverse effects that trade agreements are supposed to have had on the U.S. and foreign economies. There are, in addition to his field, in yesterday's column, Mr. Krugman noted that he's not a political scientist. Well, there are important political science implications for the TPP, which was negotiated with 13 other countries in East Asia with whom we have important relationships. There are also international security and national security implications to this negotiation. And it's nice to come out against these tribunals, and I'm opposed to them. For those of you who don't know, my day job is as an employment lawyer representing plaintiffs. I don't like forced arbitration. We rail against it all the time. But, in fact, the TPP has those tribunals in it. If Congress strikes them down, the whole deal has to be renegotiated. Now, you may say that's fine, but that's a great deal of lost political capital with other nations. It's going to be uncertainty in the markets, and I poo-poo that, but you know, it is a factor that we've seen from time to time. So I suggest that the best thing here is for us to advise our elected representatives to study hard and to make the best decision that they can, because we really don't know enough to advise them knowledgeably which way to go, and we should only advise our representatives when we are knowledgeable. And if there's one other reason you need to vote no on this article, and I would say on both motions, just remember that if Donald Trump were here tonight, he'd tell you to vote in favor.
So, Mr. Fisher?
I would bring two
Who
points.
are you?
Andrew Fisher, Precinct 13.
Thank you.
Thank you. I'd like to speak about the tribunals for a second, and I'd like to mention the Verizon strike last week, which ended last week, not in pay increases, not in new salaries. What the Verizon strike was about preserving American jobs. Where are these American jobs going? I was reading this morning an article about the contact the CWA, the Communication Workers of America, has made with the organization that's trying to unionize the call center in the Philippines, which Verizon is contracting to replace $36 an hour union jobs that are middle-class jobs in the United States with jobs in the Philippines that pay college graduates $1.98 a day. That's a race to the bottom. That's what a vote against is about. I agree with my brother, Mr. Margolis, that democracy will out, and I think democracy is demonstrated in town meetings like ours, where we speak out against this kind of attempt to drive working people to the bottom. The second thing I would talk about in democracy, in maintaining democracy, is the notion of courts of justice that allow the people remedies from corporate abuse. And what these tribunals that sidestep the laws of the United States and the laws of the other countries by saying, if we have an environmental law, if we have a labeling law, if we have other laws that hurt the profits of the predatory corporations, then the corporations under these trade agreements have a right to bypass the law, bypass the democratically elected protections that we impose, and go to the tribunal and say, your attempts to make us comply with environmental standards, your attempts, and this happened with the meat labeling law, where the United States is no longer able to identify the source of meat products because it affects the profits of corporations who are importing meat that we can't verify the source. And the tribunal is a way around democratically elected laws. These are just two examples of why these trade agreements are not for the benefit of the workers, of the people in either our country or the other countries that are signatories, but are for the benefits of the corporations who are seeking to create a system of being above the law through these trade agreements, which, if we are not informed, it is because these terms of the agreement are being hidden from us. Congress is not being informed. Congress is being asked to vote without knowing the details, because if they knew the details, if I were in Congress and didn't know the details, I wouldn't know how to vote either. So I would ask that we go on record as voting against the trade agreement in the stronger fashion. Thank you.
Ms. Heller?
Nancy Heller for a majority of the Board of Selectmen. We voted 3 in favor, 1 opposed, and 1 abstention on the motion offered by the petitioner. And you've heard much about the motion. I don't want to go over those grounds again, except to say this, that first of all, I want to deal with the issue of why we should speak out on issues like this. We've heard arguments in our debates over resolutions dealing with national and international issues. Why shouldn't we just stick to Brookline matters? And Mr. Sandman alluded to that in his presentation as well. But about 2 years ago, I would remind you that we supported a resolution that opposed the construction by Kinder Morgan of a natural gas pipeline from the fracked gas fields of Pennsylvania through New York, through the Berkshires, into Drake, Mass., and from there into New Hampshire and Canada. And our efforts, along with many others who also opposed this pipeline, resulted in a decision by Kinder Morgan not to continue to pursue this intrusive anti-environmental pipeline. So our voices on matters outside Brookline borders do make a difference. Just as that pipeline would have a negative effect on the environment, which would affect us all, the TPP could also negatively affect us. We voted on the petitioner's version. We believe that it's the most complete. We focused on the inclusion of the investor-to-state dispute settlement system and took a similar position to that of legal scholars Lawrence Traub and Elizabeth Warren, who oppose the inclusion, principally because it does not provide procedural protection and has a system of adjudication with very limited accountability and review, which is antithetical to the legal principles that Americans expect. Particularly troubling is that the TPP would expand the current ISDS system, which is in the other trade agreements, but this time it would be expanded, allowing multinational corporations extraordinary new powers to seek cash compensation from taxpayers by challenging U.S. government actions, laws, and court rulings before foreign tribunals, whose rulings could not be appealed on the merits. The number of cases brought under the ISDS system of other trade agreements has mushroomed in the last 5 years compared to the 30 years prior. That means that our costs have also mushroomed, for even when the government, our governments, win cases, and that's U.S. and municipal and state governments as well, they're often ordered to pay for a share of the foreign tribunal's costs, potentially creating a chilling effect on our policymaking. This chilling effect is enhanced when coupled with the ability of multinational corporations to seek cash compensation from taxpayers. The inclusion of an expanded ISDS system poisons the TPP irreparably. Let's conclude this town meeting by voting favorable action on the motion offered by the petitioner. Thank you.
This town meeting has at least a 45-year tradition of taking positions on international and national issues over which it has no control. Well, I'll take that motion. Is there a second to the motion to terminate debate? Okay, it takes a 2/3 vote. All those in favor of calling the question, that is terminating the debate, please raise your hands. Those opposed, motion carries by a 2/3 vote. We'll deal first with the advisory committee's amendment of the main motion before you, which is the motion on the Lavender supplement entitled Motion to be Offered by the Petitioner. The advisory committee would delete the first whereas clause. Those in favor of the advisory committee's.
I have a legitimate point of order. I'll state it. Marty Rosenthal, Precinct 9. Are we voting now on this as we did on Cuba as a substitute motion, or are we just voting to amend the main motion?
No, we're voting to amend the main motion by deleting the first whereas clause.
All right, thank you.
And on that motion, those in favor, please raise your hands. Those opposed? Those in favor, please raise your hands. Yeah. For first whereas clause. Yeah, I'm sorry. Yes. All right, just to be clear, this is the advisory committee motion, which would amend the petitioner's main motion by deleting the first whereas clause on page 1 of the Lavender supplement, which reads, whereas U.S. trade deals over the past 25 years, etc. Those in favor of deleting that clause, please raise your hands. Those opposed, motion fails. On the main motion of the petitioner, those in favor, please raise your hands. Those opposed, motion carries by a majority vote. Before I'll take a motion to dissolve town meeting, but I want to point out the reports that have been submitted under Article 23, which I commend to your attention. There are 3 interim reports by moderators' committees authorized by this body, and most importantly, perhaps, a 31-page report on the bottled water issue by a selectmen's committee, which I've been asked in particular to bring to your attention. I will now entertain a motion to dissolve the annual town meeting. Is there a second? Those in favor, please say aye. Those opposed, no. The town meeting is dissolved. Thank you, ladies and gentlemen.